Welcome back to our second panel. I think the first panel teed up the basic question of the second panel really well in many ways. The panel is entitled Alternative Accountability Mechanisms, and I'll explain a little bit what's intended with that title. But first, let me introduce our panelists, going from my left to your right. First is Antonia David, who is the legal director at Interjust. Welcome. Next to Antonia is Rebecca Hamilton, who's professor of law at American University. And finally, our dear friend and alumnus, who's had some career success since he left us last, who is Sebastián López de Castro, who's dean of the School of Social Sciences and professor of political science at the Pontifical University of Javeriana in Bogotá, Colombia. So welcome all three of you. It's great to see you again, Sebastián, and welcome back. And it's really wonderful to have our two friends join us as well. Here's the idea for this panel. I suppose the frontline legal response to atrocity crimes, both in a backward-looking sense of bringing accountability and the forward-looking sense of prevention, ever since the middle of the 1990s, has really resided in the field of international criminal law. And thinking back to what David said about Americans' peculiar, I think that's a generous, peculiar attitude toward international law. ICL, international criminal law, for those of you who remember your first courses, divides atrocities into three international crimes: the crime of genocide, the crime of crimes against humanity, and war crimes. And of course, as any crime, crimes are committed by natural persons, not by states. And so the idea that arose from the experiences of the 1990s, the institutions that arose from the experiences of genocides in the former Yugoslavia and in Rwanda, was really a sort of a massive structural institutional shift, sort of away from the primacy of international human rights law and toward this new international criminal legal model that held individuals accountable for what are essentially collective and highly complex collective acts typically of states in preying upon usually their own citizens. And that shift spawned a whole bunch of new legal institutions in the 1990s, the UN-sponsored international criminal tribunals for the former Yugoslavia and for Rwanda. It was the driving force behind the creation of a permanent criminal court, the International Criminal Court, at the turn of the millennium, and continues a quarter century later to be, I think, in legal terms anyway, the default or the frontline approach to how we think about and how we operationalize law as a mechanism for accountability, backward-looking, as a mechanism for prevention and deterrence, forward-looking. It's always been a very uncomfortable set of institutions and practices, and especially practitioners of international law have always understood very vividly the severe limitations that this dominant paradigm of law imposed upon us. And I don't need to go over those limitations now. There's always been a keen interest in whether or not alternatives to the primary model of individual criminal legal accountability for atrocity crimes are available. If so, should they replace or merely supplement the frontline idea of holding high-level perpetrators to account and by charging them with crimes and potentially conviction, locking them up as a way of imposing this accountability? Once again, and just following up from the last panel, the obliteration of the American legal framework for participating in the global project of international criminal law is a loss, but also an opportunity, because whatever comes next, we can't say that the model that was developed over the past 30 years was perfect by any stretch. There were severe limitations and problems. And so one of the things that I asked our three panelists to talk about is, because they are all deep experts on ICL, is asking one simple question, maybe not so simple. What are alternatives to the dominant paradigm of holding individual perpetrators, ideally, but not often in practice, high-level perpetrators, criminally accountable for atrocity crimes, trying to bring them to book, trying to impose upon them a fair and public criminal trial, and if convicted, locking them away? How has this been successful in whatever sense you mean by success? What have been its notable and most significant failures or drawbacks? And what is on the horizon or is new in trying to understand how law can work, or paralegal means can work, as ways of expanding what could count as accountability for atrocity crimes? So I'm just going to start things off by asking each of our panelists to give us their, I guess, 3-minute elevator pitch in a way of answering that question. And I think that the idea here is that after the third of them has finished, I'm going to give each of them a significant look, which means now it's time for you to talk to each other and don't talk to me. So we're going to start off with Antonio.
Sounds good. This works, yes. Hi, everyone. Thank you for inviting me to be here. It's very great to be here in this room. So it's a very ambitious question that I will sort of answer in terms of the work I do. So I come from sort of the practitioner side, the NGO side, and the work we do is all around universal jurisdiction. And so many of you may have heard of these cases, but they're essentially squarely within the international criminal law world, but using domestic courts, not looking to the international tribunals, the international criminal courts, but using national courts as sort of the way forward. In this vein of the future of international law is domestic. And so what we do is civil society has a particular role in this, but what we do is support prosecutors in investigating and prosecuting war crimes, crimes against humanity, and genocide, working across different regions in different contexts. But we sort of see that as the way the system was actually built, right? So the ICC, for its mandate, per the Rome Statute, was always meant to be a court of complementarity, a court of last resort. Many of the tribunals as well, the human rights side as well. And we really are looking to build domestic capabilities to do this work. And then if you sort of look historically, I guess, at the last 30, 40 years, there's been a huge increase of these sorts of cases. A lot of them in sort of the countries you see in the headlines all the time, cases in Sweden, in France, in Germany. I'm sure, right? You've seen the Rwanda cases in France, the Yazidi cases in Germany. But there's been kind of a good expansion. We have a case in Argentina. There are many investigations currently unfolding in Argentina. We're trying to start cases in Africa, Asia Pacific as well, because what we've realized is there's this incredible capability to bring these cases with laws that already exist. Most of the world's countries have laws that will let you do these investigations or prosecutions. And so it's more about finding sort of the practical ways of actually making that happen and supporting these investigations. I'll leave my 3 minutes there.
We were wondering if we could sort of create some optimism with this panel. And I think that maybe there's a pathway there in that the tech piece, which I'm so skeptical of on so many levels, is coming together in ways that can be helpful when we think about pushing cases out domestically. Okay, to the sort of nominal question though. So I used to work at the ICC, right in the thick of doing traditional international criminal law. My frustration with the model is that it has created this narrative in the public mind of when we think about war crimes, crimes against humanity, genocide, we are thinking about either direct perpetrators or masterminds. And yet, putting my atrocity prevention hat on that will resonate with so many of the people in this room, if we think about what it takes to actually prevent mass atrocities, which by definition are at scale and sustained over time, we have to look at the enabling environment in which both the masterminds and the direct perpetrators act. And when we look at that enabling environment, one of the actors that is a through line from colonialism onward are corporate enablers. And so because of the history of, another wonderful thing about the conference, I got to be speaking with a historian on the wall over here today. I'm not just surrounded by lawyers, but looking at the history of Nuremberg and the decision, I think potentially monumental decision not to hold the planned second international trial that was going to focus squarely on the industrialists, means that the narrative that we as international criminal lawyers have told ourselves, which very much starts with that Nuremberg moment, has really got a huge blind spot around corporate enablers. And yet, to Antonia's point, there is a whole world of forums out there, not just in criminal, but also in civil accountability that is ripe for looking at these corporate enablers as targets of accountability. And what I especially love about this as one of the things to be pursuing is, you know, I've spent a lot of time with survivor communities all across the world, and there's never a one-size-fits-all to what people want in the aftermath of mass atrocities. So you get as many different opinions as there are people. But certainly you can't say that everyone always wants to see a perpetrator go through an international criminal trial that is in some distant place. Often people do, but it's also that and. And when I try to pull together what that and looks like, two of the themes that consistently come up are a sense of reclaiming agency. So can I rebuild my community in the way that I have some control over what that looks like after that agency has been stripped away from me? And secondly, and this one is consistent, can I be confident that my children are not going to be facing this same situation? And to the degree that whatever accountability mechanisms we are setting up are supposed to be, I think we can have a longer conversation about getting drawn away from this, but are supposed to be in service primarily of the survivors, then I think that looking at the enabling environment can speak to both of those issues, particularly when you're talking about corporate actors, you're talking about people that actually have pockets that are filled, that can help towards the agency piece. Money isn't everything, but it's something. And then if you're really taking prevention seriously, you've got to be looking at the enabling environment.
Okay. I'll try to be also a little bit optimistic after the first panel and after, reviewing the situation, the current situation. You could get really pessimistic, but I, of course, try not to be naive about these things. But I want to say that, and I want to build these comments from the case of Colombia, where, as many of you know, the government of the country and the largest guerrilla group signed a peace agreement 10 years ago, after probably 60 years of an internal armed conflict with several human rights violations throughout the country. Many armed actors, different actors, guerrilla groups, paramilitary groups, and the military, all of them committing mass atrocities in different regions of the country against indigenous groups, Afro-Colombians, and different communities. Almost 8 million people forcibly displaced, 100 20,000 disappeared, 50,000 people kidnapped, and so on. You know, a lot of mass atrocities. So this peace agreement that the government signed 10 years ago was built with the perspective of the Rome Statute and the ICC, the International Criminal Court, trying to adjust the transitional justice system to that international regime, and avoiding to reach the point in which perpetrators were prosecuted at that court. So in that sense, I would say that that international structure or regime has worked for the case of Colombia, because it was the main reason explaining the architecture of the transitional justice design, in which one of the main actors, but not the only one, is the special jurisdiction for peace. An alternative model of prosecuting the higher level offenders and jurisdiction that has applied, which I think is one of the, and trying to answer your question, one of the things that is, I think, the most disruptive approach to accountability, to prosecute those responsible, which is the restorative justice approach. And I think that's fundamentally different from what we have been trying to do in the past decades, because the whole point was to reduce the impunity gap, to prosecute those responsible, no matter what. And that's the point of the universal jurisdiction. It's, even though in particular countries those responsible are not accountable, well, there's an international regime that is going to do that instead. But in this case, the restorative approach is putting in the center not the perpetrators but the victims, the survivors, and I think that's fundamentally important and radically different in this peace process and in this transitional justice process. Because the important thing is not to put those responsible in jail for so many years or whatever the sanction is, but is to restore somehow, to some extent, the lives of those who were victims of the human rights violations and the mass atrocities. So the approach, the restorative approach, requires perpetrators to do different activities, projects, and works with communities and victims in trying to restore, to some extent, the life that was, disrupted before, instead of spending time in jail. The restorative justice approach also includes some limitations to the mobility of perpetrators, but not spending time in jail. And I think this is difficult for many people to understand and to accept, because we want justice, right? And we think that justice is made by spending time in jail, and that's part of the thing. But the most important thing should be the victims, the survivors, and trying to do something to restore their lives that were disrupted. So I would say that the restorative justice approach is fundamentally important in thinking about it in something different for the future. And I would say that for the case, at least in the case of Colombia, that international regime has played an important role in adjusting the domestic process, in trying to mobilize the resources to have some type of justice that would be acceptable nationally and internationally.
Are you ready for the significant look?
I'm on it.
Okay.
I'm-
I'll say, keep my partner drive.
I'm cheating a little bit because we started this conversation at the bar last night, but, you know, that phrase of we want justice, that scrutinizing the who's the we in that. We got into a conversation last night about the challenges of introducing the notion of restorative justice rather than punitive justice when faced with this idea that justice is punitive. And I was asking you about sort of pushback to the restorative approach in Colombia, and your answer was so interesting that I'm just going to prompt you to share it in terms of the schism between victims and non-victim communities.
Exactly. No, and it's very interesting because not everyone is, not everyone see the justice the same way. And of course, when you ask about the we, is, the society as a whole, in the states and NGOs and different actors want to have some kind of sanctions, because that would be a way to close a process, But victims actually need different things. Sanctions would be part of the solution, but not everything. What happens? Let's think about people who have been forcibly displaced from their homes, and they had to leave and flee from violence. Restoring their way of life should include guaranteeing the meanings and the needs that they have. They need to survive, and not just to know that the perpetrators were in jail. They need also opportunities to be engaged in civil society. But of course, people who haven't been involved in the process and see things from a certain distance don't understand, or usually don't understand the same way the potential of restorative justice. So we were discussing about how victims actually embrace that process and value that process. In our university, we have also invited, victims, mothers of young individuals who were disappeared and killed by the military, with perpetrators, colonels and generals who were involved and recognized that they did the orders and they committed those crimes, and also former guerrilla leaders. And all of them discussing, acknowledging what happened, and discussing what happened, and the victims, the mothers, thanking them for being in that process and accepting the forgiveness that they were asking. So they are willing to be involved in these processes, but for some people in the media, or maybe others who are not victims or just commenting on the issues, still think that justice should be made by putting those perpetrators in jail. So it is very interesting seeing the difference between what victims are feeling and what they are saying in the process, accepting this kind of a process that leads to reconciliation, more than just punitive justice. And between the defense of those victims and people, seeing from the distance. So that's one of the challenges that we have, trying to reach out to the society at large and explaining the potential of these types of approaches.
So let me jump in with a question then. I mean, this is extremely interesting. I have a question specifically for Antonio on that, following up, but for all three of you, one of the extraordinary parts of the Colombian process, was how many stakeholders there, how many voices were included in that debate, including international voices. such as the chief prosecutor of the International Criminal Court. And one of the things of Fatou Bensouda at the time, one of the things that she, I think, rightly reminded the Colombians of, and wanted to make sure that they knew that she was watching them, was her point that as signatories of the Rome Statute, or of the Genocide Convention for that matter, Colombia's discretion to decide how to handle international crimes was limited, that they had a duty to punish. And failing to punish, they would be in breach of important international obligations. The way that Colombia finessed this particular problem and tried to, have it at both ways, as it were, is fascinating. So first I want to start with Antonia. So the general question is, are you worried about this? I mean, are you worried about yeah, we have important international treaty obligations to punish international crimes, but we think that we retain enough wiggle room to sort of keep you happy while doing what we think best for our country. Should I be worried about that kind of process? And for Antonia, isn't the one way to think of universal jurisdiction is of other better funded, better endowed countries picking up the slack for countries that are, as the words of the statute is, unwilling or genuinely unable to do these prosecutions.
Can I actually go back to the victims?
No.
Question first.
No.
Which sort of feeds into actually the answer to your question, I think. But I completely agree with your point of, we often talk about survivor-centered approaches and what do survivors want, what do families of victims want? And it is treated as a complete monolith, as if there is one or two or three right answers, and it will completely, as I'm sure many people in this room know, it will completely depend on 500 different factors. And sort of when I'm thinking about our cases, right? So for example, our Venezuela case, it's crimes committed in Venezuela by security forces there, which we're pursuing in Argentina. And there we represent two families who had family members who were killed in Venezuela by security forces. And for them, so the families we work alongside, they're more in this camp of, we do want justice, we do want to pursue some sort of accountability, and what that looks like, then that's a conversation. But for example, these two families, it was very important for them to actually give official testimony in front of an impartial tribunal. And so that's what they have been able to do. Our case is in it's a pre-trial phase where the investigative judge was taking testimony. And so we brought them to the court, they gave official testimony. And the mere process of that, as we were saying, right, it's the process, it's engaging in this justice process, whatever it looks like to survivors. Just the mere act of engaging in it, like our conversations with them have been so different after that. Sort of the value in that, in having this process and having a place to go, was already doing so much to sort of heal in as much as can be possible in that case. But then conversely, so I just came back last week from Uganda, where we're considering, thank you for mentioning Sudan, we're considering taking on a possible Sudan investigation. And so we were in Uganda meeting with Sudanese documenters, so people actually on the ground who in the last 3 years have sort of witnessed and suffered some of the worst things going on in the world right now. And for them, it was a very different conversation. It was all about deterrence and prevention. And can we do something in the accountability space? Because many things have been tried, many things have not succeeded. Is there something we can do in the accountability space just to stop this, to send flags and signals? So that was a very different conversation with survivors and families of victims. And so I think sort of having that at the front and center, exactly as you said, should be the determining path for this. And then I think just the final piece to answer your question, I actually don't think it should be universal jurisdiction cases should not be happening where sort of all the resources are, right? It is, the whole point of it is that it's a shared responsibility, right? We say these 3 crimes, 4 if you add aggression, are so grave, everyone should have the ability to investigate and prosecute them. And I think it's 3/4 of the world's countries have some sort of law that would let them do it. So they should, right? And we can have a conversation about resources and practicality and politics and diplomacy, but sort of normatively, right? It is a shared responsibility, and it's about sort of closing the ability of perpetrators to take advantage of impunity.
So I want to add in another layer. I think we're pretty much all lined up, and I suspect with more or less everyone in the room on the value of survivor-centered approaches, and that they don't look the same for everyone, everywhere, and even don't look the same over time. And the value of, to the extent that these crimes are at their core about the removal of agency from a community, usually, then the restoration of that involves putting that community in the driver's seat around what the aftermath looks like. But they're also not the only community that is relevant when we think about prevention. And I was thinking to your point about there are many countries in the world that have laws on the books that could prosecute these kinds of crimes. Very few of them are actually doing it. Now, part of that is about expertise. It's really different prosecuting a domestic crime to prosecuting one of these crimes, and that can be dealt with through technical support, much harder now. There's no US funding. But it's not only that, because in a lot of places, it is a political decision by a public prosecutor. Am I going to put resources into this crime that happened in some other country, or am I going to prosecute this crime that is right before me that happened in my town or city? And part of the story about how you get those prosecutors to make the call to prosecute something that we have said is in the interest of the entirety of humanity is if that prosecutor is working, I'm assuming a democratic system for the purposes of the argument here, in amongst a public that understands the value of doing that. And so any of these accountability mechanisms, whether it is a traditional punitive mechanism or it is a restorative one, also have some educational and expressive component that goes out beyond the directly affected communities and thinks forward that this might be the directly affected community today, but what are going to be the future communities that need to understand the value of this, both in case these crimes hit their communities, and the US is currently such a cautionary tale on our assumptions about what happens here and there, which were already problematic to begin with, but also in terms of opening up the number of forums for pursuing accountability around the world. And so while it is both about putting survivors front and center and being engaged in the process, it has to also be about the expressive value that goes out beyond that community if we're going to really be able to take prevention seriously over the long term.
I would like to add to that point also the need for political support and educating the political elites, because these approaches, these alternative accountability approaches, imply also an investment, financial investment from the state in order to conduct a lot of projects or activities or whatever the restorative approach looks in every place. So it requires political decisions, political willingness, and resources to fund the process. And Therefore, we need to work on educating those people who have to make those decisions. And it's very important. So the role of education is key because this requires a change in the mindset to understand how to better prosecute those responsible and how to to achieve reconciliation, non-repetition, and all the things that we are looking forward in this transitional justice process. Education and political support for those approaches.
Antonio, I want to bring you in on Ukraine because we're, the scale is always overwhelming when we're talking about mass atrocities by definition. But the numbers that we hear of individual cases, like more than 100,000, how does a system respond to that in a meaningful way, and what are the conversations you're engaged in on that?
Ukraine has been such an interesting from a legal perspective. I know that sounds strange, but you know what I mean, right? It's been such an interesting case study in international criminal law, sort of deploying in all these different mechanisms. So, as some of you might know, right? So Ukraine, at the start of the full-scale invasion in 22, did not sort of have it didn't domesticate the Rome Statute, had some general laws around war crimes, essentially, and aggression, but not sort of in the way we consider sort of Rome Statute crimes to be applied. And so when the full-scale invasion broke out, and Ukraine did not collapse as a state, the prosecutor's office continued to do its job, law enforcement continued to do its job and started investigating international crimes that were now occurring on its territory. They essentially opened a case for every crime that they saw. I think it's currently 190,000 cases are opened in the last 4 years, which literally means, you see a body, you open a case, a bicycle stolen, you open a case, right? There's not this kind of bigger pattern that we often see in international criminal law cases where we, in an area, there was sort of a pattern of detention and executions. We consider that a case, right? This was much more systematic, or sort of not systematic, individualized. And so that was sort of Ukraine's approach based on their domestic criminal procedure and laws. And so what we've seen, a lot of the international support that they received, have a different conversation around that, but a lot of the international support they've received from experts has been around sort of internationalizing the approach, identifying patterns, identifying priority cases, working with all these different institutions that support this investigation. We have an ICC investigation for Ukraine. We have an aggression tribunal, hopefully, once it gets going. We have a reparation in the claims committee for reparations. We have a joint investigation team. I think it's over 20 countries that have joined this bit and the ICC and formerly the US, not anymore. Yeah.
We were never part of it. We were just friends.
We're
of the
advising,
chat.
right? Okay, yes. But still, big step for the US when it was part of it. So there were all these different opportunities to sort of engage with different strands of international law. And I think what we're seeing now is a lot of that has actually been, they did domesticate the Rome Statute last year. It's now been implemented into their domestic system, which will in the future allow them to prosecute cases much differently. But there has been this sort of integration of international kind of norms, interpretations, approaches to investigation into the domestic system. But I do think it's sort of a specialized case because for many reasons we can talk through, right? It was Ukraine. And there was this huge national attention and all these mechanisms that were set up that do not exist in basically every other.
I wanted to circle back, if I could, to something that Beck was describing in her opening elevator speech, which was, I mean, so far we're rightly, I think, still sort of talking about how to continue to best operationalize the existing framework of international criminal law, which requires, you know, the prosecution of individual persons. Beck, what I heard you saying was, yes, but there's this entire different dimension of enabling institutions, primarily corporations, including international corporations, that consistently seem to fly under the radar. I think that was the case for the final accord as well, that there was I think a good faith effort to include corporations in the accountability mechanisms of the final accord that went absolutely nowhere. So I wanted to ask Beck, and then maybe other people can chime in. Imagine you have a corporate accountability toolkit and you open it up. So there's not going to be that many criminal legal tools in it.
International.
Yes. There's going to be other kinds of legal tools in it. There might be political tools in it. There might be advocacy tools. There might be, you know, public campaign organization tools. So walk us through. You flip open. You say, this is the time I'm going to pivot to being an activist for corporate responsibility for the enabling of atrocity crimes. And you say, here's my toolkit. You flip it open. What's in it? What are the tools that seem to you to be the ones you'd reach for first?
Oh, what a great question. There are so many tools, but the number one thing that I think is required to unlock that toolkit first, and this is why you're going to hear me talking ad nauseam about this, is shifting the public narrative about so I'm embarking on this book project that is tentatively going to be called White Collar War Criminals, because I think there is just not the connection in the public mind for the most part. If you're a corporate actor, you get a presumptive pass, and there is so much effective PR marketing strategy work that has gone on over decades that one favors self-regulation on the grounds that other people don't have the expertise to understand what we're really doing. And so therefore you should leave it to us to be the good guys. We are seeing this times on steroids in the tech space, which is another conversation we should be having. But also this sort of notion that, well, they were just going for profit. And that if you can argue that it was going for profit, somehow that's a shield. And you see this in the transcripts from Nuremberg also. So it's not like this is a new thing. And then we didn't have that kind of Nuremberg precedent. So what we instead got was this notion of corporate social responsibility, which, by the way, can do some really effective things at certain levels, but I think has already proven itself definitively to not be up to the task when it comes to the kind of mass atrocity crimes that we're talking about here. But anyway, I think if you can shift the basic public perception and open us all up to the idea that, in fact, corporations can be war criminals, then the legal tools were already there. That's what's so interesting about this. Like, domestic criminal law can get corporations. In not every jurisdiction, but plenty of jurisdictions around the world. Civil law actions against corporations are extremely effective from the perspective in particular of survivors, because even if you don't get to trial, you'll often get a settlement, and that is money, and that helps you rebuild. But there's also, I think, a reckoning, and I suspect, I mean, it'll either come through the AI conversation or it won't, maybe we're all doomed, but a reckoning around the role of regulation that needs to just stop giving a free pass to this idea that, well, if you are either pursuing profit, or the other part of this narrative is, well, you're innovating. So if you're innovating, then we somehow have to let everything else slide. And no surprise that so often these innovations in the tech space have been done in places geopolitically where those countries have the least power. So if I think about Meta rolling Facebook out into Myanmar without community standards, without things functioning, and the inevitable incitement of genocide that followed from that. So the toolkit is there. I think shareholder activism, again, could be part of that toolkit. There's so much to mine. And people are doing it kind of a little bit piecemeal, but I don't think they're thinking of it from a massive atrocity perspective, which is where I think it has so much potential.
Make something up.
Maybe I want to ask you about the financial sanctions against individuals, but also corporations as a way to prevent that they continue funding mass atrocities with their arguments. How do you see those sanctions, financial?
Yeah, I mean, I think all of it is in the toolkit. The trouble with making financial sanctions effective requires multilateral coordination. And that is, one of the ongoing challenges that we're facing. But I think once we just kind of break out of anything that's bad has to go to the ICC, which has been, I'm generalizing and it would be unfair to many of the people in this audience, but I do think there's something there of certainly, as someone who works in this space, every time the word genocide gets uttered in the public sphere, there will be someone calling me and saying, do you think there'd be an ICC case here? And that's just a very, I hope the ICC can survive. I think it has important normative value to have it. But it is just such a thin conception of all the different avenues that are out there when we're thinking about accountability, particularly as we connect it to the story about prevention.
And to add on to that, the only criminal accountability that has happened has been in the universal jurisdiction space, right? In France, in Sweden, in the Netherlands. I think there's 4 cases, not a lot, but those are the corporate complicity in international crimes cases that have actually proceeded.
So just on that point, I'm just trying to make some lemonade here. On the case of universal jurisdiction, I mean, the United States, of course, has always been one of the most effective and powerful opponents to universal jurisdiction. If you think back to the Belgian experiments 15 years or so ago, I think this was during the George W. Bush years, that the United States was so exercised about the Belgians exerting universal jurisdiction that I think at one point they actually threatened to pull NATO headquarters out of Brussels as a sort of a naked threat, which seems like a pop gun these days, but at the time it was a pretty big threat. So one of the things about sort of universal jurisdiction as a rerouting the energy of international law around a sort of a frozen Security Council, a frozen or an underperforming ICC. Here's the lemonade. Do you think that now that the United States' entire international legal infrastructure has collapsed within the space of months, do you think that this has opened up opportunities for more and more effective coordination across countries for universal jurisdiction, or is it just going to be as difficult and cat herding as it has always been? I might have loaded the question just a little bit.
So, okay, there's a few ways to answer this, but I think the beauty sort of having national courts having national courts tackle these cases is that you're not dependent. Yes, we can talk about, and we should talk about sort of the political diplomatic component, which is huge for these cases. But putting that major thing aside, they don't sort of rely on the US, or they don't rely on major powers, right? If Poland decides to prosecute a case on war crimes, it's not relying on the US for any of that, right? It's looking at its own interests, it's looking at regional interests, it's looking at its own security issues, its own sort of political and diplomatic considerations. And so universal jurisdiction sort of ends up decentralizing a lot of opportunities. There's also sort of a lot of regional opportunities to step up, right? To like Sudan, to look at other African countries that have fantastic laws around this, and to sort of meet the criticism of the ICC prosecution of African leaders and say, okay, you have the laws, do you have the will? Is this something that you sort of deal with regionally? And so it doesn't depend so much on US power or any other sort of big global power in the legal framework. The second piece of it is, of course, that for a lot of these countries, they have attorney generals or public prosecutors who actually have to get permission from someone like the ministry or foreign office to proceed with a case. And so there, the politics, of course, matter. And I think that is sort of part of what like organizations like ours do as we figure out where we might file a case, where do we try to have an investigation proceed, is considering, of course, the political and diplomatic piece.
Which is a great argument for the value of also pursuing civil cases, right? So for a criminal case, you of this scale, particularly with foreign interests, you do need that sign off of your attorney general or whoever it is, and there's a political dimension. Civil case, it's the plaintiffs themselves, the victims themselves that are bringing it. They just need the lawyer. They don't need to get the political sign off. And so I think that's another sort of reason to be expanding our set of targets and set of forums when we think about accountability for these crimes. I also would be, this might be a David question, but I don't know that the US it comes out against it has historically come out against universal jurisdiction when your universal jurisdiction threatens its interests. I don't know that it's per se across the board. Just like it.
Okay, I'm going to try to squeeze in. We're about to pivot over to audience questions. I'm going to try to squeeze in one more me question first before we. So get ready, everyone. You're up next. So far, just to sort of pulling back a little bit, we've heard about an extremely interesting Colombian experiment that doesn't think of retributive criminal justice and restorative justice as an either or, but as a both and has a very sophisticated approach to sort of combining these elements in a way that I think, if everybody's unhappy, then you're successful, right? And I think that's in some sense true of the case. We've had an argument that universal jurisdiction is a powerful but still underutilized tool for operationalizing the procedures, the promise, and the power of international criminal law that becomes more and more relevant and prominent as the sort of the big institutions that got generated from this period between 1995 and 2000 start to really show their age. And we've had, I think, the idea that ICL would also really need to be supplemented by all kinds of different legal tools, particularly in civil law, to begin to wean us away from this model of like, let's throw the president in jail. That's what we really need to do. Versus let's raise the cost on enabling corporations to make them recalculate their cost-benefit analysis for pursuing profits at the expense of people's lives. Great.
By the way,
and.
I'm not saying the president shouldn't go.
Yes, that too. So that's what I've heard so far, and this is really good. What else? Just kind of let your hair down. What else is out there in terms of, are there traditional justice mechanisms that could be repurposed in ways that are, respectful of rule of law processes that have not been tried at scale? Are there actors, non-lawyers, actors who have a role to play? What else is on the horizon of actual or even possible ways of putting more stuff into that toolbox that we just described? We'll start with you, Sebastian. I'm going to put you on the spot.
That's a tricky question. I think that prevention is a it's something that we all should be engaged in. It's not the responsibility of state actors only, but also academia, NGOs, communities should be all aware of the risks and the consequences of massacres. And by engaging a large audience, I think that we are, expanding the toolbox too. So what's in the horizon? I think that reaching bigger audience, I would say, not just the laws, the law community or the state agencies or the international usual suspects. Trying to reach out to other non-traditional actors, but that also should be engaged. Corporations should also play a good role in that from a social responsibility perspective. So they not just should be punished or persecuted, or but they also could be engaged in prevention. So that would be something. Just trying to answer your question. That I would say something. I would say that.
One of the things that I loved about coming here was learning how the program is reaching out across disciplines and adding an atrocity prevention lens, getting it outside of the law. I say this as a lawyer working in the law school. But what I really have gone deep on the role of Meta in Myanmar. And so much of that time doing that research, what I wanted was the product engineers just to have had some sense of what they were unleashing and getting that training around atrocity prevention in every single engineering school, I think would be.
What's the status of the class action suit against Meta on behalf of Rohingya victims? Is it going anywhere?
There are multiple efforts across different jurisdictions, and the law is not fantastic. We should talk more. But so in any case, broadening the mass atrocity prevention conversation out across the disciplines is something that we can be doing in the academic space. Artists are essential to this process, and at every kind of level, like locally, the work that is done on memorials and education through theatre, all of that. And at the same time, I want to see, where's my Hollywood blockbuster that is telling the story of what happened when Facebook went into Myanmar, right? So that we understand that these things should be coming together. So I think it's really just a call for a broadening of how we self-conceptualize this field that probably everyone in this room is working on.
I agree with those. I guess I will just add that even for these institutions that we feel like are very stuck, and I agree they're very stuck, especially sort of the ICC and the UN, finding creative ways to unstick pieces of them. Like for example, we've seen in the last 2-3 years that the ICC Office of the Prosecutor has been much more open to engaging with civil society on the ground, locally, regionally, internationally, to collect their information, to have that information actually be part of investigations. Whereas before it was a very clear, never, we're never taking this information from you, right? So there's been sort of, through a lot of advocacy and a lot of pressure and a lot of discussions, there's sort of an opening there to have some of these processes go forward. For the UN, we're currently, one of our only non-international criminal cases is we have a communication with the Human Rights Committee on the right to life. So using procedures, UN procedures, ours is on It's on Ukraine for a violation of the right to life due to an aggressive war. So it would actually be a pretty big challenge to international humanitarian law because we represent both civilians and military as part of this filing. To say that the aggressive act against them that took their life is a violation of their right to life. And usually, right, as you know, in war, military is a legitimate target. So sort of as just an example, right, of using sort of small spaces within these institutions that feel stuck to be more creative.
Floor is open for questions. If you wouldn't mind just identifying yourself, that'd be great. Thank you.
Hi, I'm Diana Galidas. I'm from George Washington University. So I have a question, which you didn't quite address, but something that I'm sure you've run into. So I think among the most horrifying and marginalized crimes committed in conflict and genocide or sexual violence against girls and women. And I wonder what you would say about how sort of accountability can be made more robust. I think both legally, but I would also say to some degree normatively, in part because I think norms tend to attach shame not to the perpetrators, but to the victims themselves, right? Creating sort of an extra obstacle to accountability. So I wonder if you can share a little bit about, say, Ukraine or Sudan or places like that. Thank you.
I think conflict-related sexual violence has been the most interesting, one of the areas where we see the most difference across our cases. Stigma attached universally, but it shows up in different ways. So for example, in our cases in Ukraine that we've brought, so our cases are filed in Germany and Austria. And our case in Austria is on behalf of two survivors of sexual violence who essentially started working with prosecutors in Ukraine, and because of the way the investigation was treated there, of not being particularly survivor-centered or conscious of the violations they'd suffered, they wanted nothing to do with it. They did not want to proceed. And so they saw sort of as going outside of their context, of their culture, of their own legal system, as an avenue for actually, because they did want to pursue justice, they did want to file a court case. And Ukraine to them was impossible for this. And so we went to Austria, which has very good laws, especially around conflict-related sexual violence, specifically around universal jurisdiction. It is one of the grounds with no statute of limitations. And then in Sudan, it's been a completely different kind of realization of the scale of the sexual violence that is happening is so massive that people just talk about it. It is we're finding witnesses, victims, survivors, but also just witnesses, doctors, social workers, psychologists who are just being inundated by women coming to them, basically telling their story, which is very different from what we see before. But I think it speaks more, the only way we've been able to explain it so far is I think it speaks to the scale of, in a very short amount of time, rape and sexual violence properly being used as a weapon of war, that it's affecting this community very different and makes sort of the possibility of bringing a case or pursuing many other kinds of accountability possible. So I think it's universal in many ways, but it really does seem to be coming out differently in different contexts.
One other thing on that, I think over the course of my lifetime, the role of conflict-related sexual violence is really there's been extraordinary work that's been done by advocates, many in this room, I suspect, right? It has gone from something that was not even acknowledged as an issue when it came to talking about mass atrocity crimes to something where it is always on the list as something to be looking out for. And I think we don't want to take that shift for granted. Like so often we're frustrated at lack of progress, but that's one where there has been progress and it's not enough and everything else, but it's there. So just as I try to say something positive, I'm then about to counteract myself because one of the risks that I'm worried about as we become increasingly dependent on digital evidence in international criminal law is that it risks once again putting conflict-related sexual violence under the radar because it is just kind of as a fact of how these crimes are committed that you are more likely to get your video footage of a bombing or a public execution than you are of a rape. And so that's one of the things that I kind of have my eye on.
I would just say that when investigating cases, sometimes courts need to pick very particular cases or macro cases or patterns of systematic violence. And it would be really important to keep in mind sexual violence as one of the main types of crimes committed throughout conflict. So in picking and selecting the cases, I think it's very important to also include sexual violence as the main priorities. And that would be the key, because as we were discussing before, it's very difficult to investigate every single case that happens during an armed conflict or a mass atrocity. And then the justice system and the courts need to pick or select certain prominent cases that would be, paradigmatic, or they would be a reference for the press. And sexual violence comes to play and should be one of the main priorities in selecting those cases.
Yes.
Thank you. My name is Tanya Domi. I've worked in the Balkans, really working in the Balkans over the last 32 years. Kosovo, 20,000 rapes. There hasn't been any prosecutions. None. We're talking about, I was just in Canada for a refugee celebration in the Kosovar community the last 25 years. And this is just unacceptable in my view. There is no extradition treaty with Serbia. They do not cooperate. So there's only been 2 people speak publicly. Now men are coming forward. And I want to make a point here on sexual violence. There is extensive research on men that were raped in Bosnia, because the longer the detention, the more likely these crimes have been committed, and the trauma is extensive. So same thing in Bosnia. Now men in the last 5 years have come forward. So we're talking about both women and men with extensive trauma. And we have a universal jurisdiction case actually being prosecuted in Montenegro now, 33 years after the fact. And people are dying. That's the other pressure you're beginning to get, is that many of the assailants are dying or they're old, and even survivors as well. So I have this sense of urgency about what do we do to scale up prosecutions. And I do take note of the Yazidi case in Germany that happened, and I have a colleague who was involved in that, but And I appreciate that. I completely appreciate it, but we're nowhere near a scale to address. We're talking about Ukraine crimes alone boggle the mind. So I want to make a point here. It actually is, it is domestic, and I was very involved. I also served in the United States Army. I was very involved working with Senator Gillibrand on prosecuting rape in the U.S. military. And what we did in that case is we proposed taking those cases out of the chain of command under military command and creating a special prosecutor. And that's what I think we have to do on conflict-related sexual violence. Why don't we create special courts with special prosecutors to address these crimes? I'm just going to throw it out.
So I don't know if I have an answer to the direct question. I really appreciate the story of the rape of men is persistent across conflicts. It's not just Kosovo, and it's really important that we keep that in the conversation because the stigma is often even greater depending on the society that you're in. I mean, I guess to the 30,000 rapes point, I think it goes to this discussion of with mass atrocities, we're always operating at a scale where you're not going to get 30,000 individual cases, right? And so then it's a question of what Sebastian was speaking to about how do you accurately represent what has been a pattern in the conflict in the cases that you're choosing. I think I'm hesitant about, I can see costs and benefits of a special court in terms of like from the stigma risk and people wanting to kind of be diverted off into a court and implying that it's somehow distinct from the rest of the conflict. There may be problems there. On the other hand, you could get expertise around how you handle these cases properly.
Thank you. Thank you. Let's a few more succinct questions, please.
Thank you guys so much for coming. It's been really, it's been great to hear from you guys and the important work that you're doing. My name is Miriam. I'm a student in the GMAT master's program. I wanted to kind of circle back to the survivor-centered approach and you know, building these accountability mechanisms that really allow victims and survivors to lead the charge, so to speak. I guess my question is sort of wanting to hear examples or understand how that education process can really be contextual, but you know, yield results when it comes to giving survivors and victims the vocabulary for what's happened to them and helping them actually feel empowered to speak about what's happened. You know, just like we're talking about stigma with different sorts of cases, but also just cultural implications of whether people want to talk about what's happened to them, and then how that trauma sort of builds on multi-generationally. And it comes to you maybe a grandchild wanting that legal accountability, but their grandparent that actually faced that crime is, you know, no longer there. And so how does that sort of work? So yeah, if you guys have any examples of things where that you've seen results.
Well, there are several or many different cases and examples, but I'm thinking on the case of Colombia and this restorative justice approach that I was telling you about, and the way in which victims have been involved in the entire process is extraordinary. From the design of the system, the justice system, to the investigation process. The victims have been all the time engaged in the process. They have been accompanied by social workers, psychologists, you know, interdisciplinary groups, and they have been present in public hearings, first in private ones, where they are prepared to learn about the language, what's happening and different things. They have also legal teams, of course. But then in the public spaces, they are the first to talk. And that's very important. It's not just the court ruling or, giving the sentence or the sanction and the offenders acknowledging the truth of what happened, but the victims also saying what they need to say in those spaces. So in that process, in those type of processes in Colombia, I think that's one of the examples, but of course in every case, it depends on the community, the victims, the type of violence that they suffer. But in general, throughout the process, they are involved in every step. And the sanctions include that the victims have to accept the words or the projects or the initiatives that the perpetrators are doing. So by engaging victims throughout the entire process, I think that that gives a little bit of that restoration or the restorative approach that the process is looking. But there are many different examples depending on the case.
Thank you. My name is Ernesto Verdeja with the University of Notre Dame. I have a question about, in terms of prosecuting folks where it's hard to get them for atrocity crimes specifically, do you see the use of, for instance, cases around corruption, going after people based on some kind of financial or other types of corrupt practices, as at least something that can be integrated into the way we think of atrocity prevention accountability? And I'm not a lawyer, I'm a political scientist, so I honestly don't know. But I'm thinking of the case of Peru with Fujimori, for instance, which that seems to work relatively well.
I mean, my experience of that on the Sudan front, because there's been corruption, there were corruption charges, there was a corruption trial against Bashir at one point. And, like any reaction to anything, it was mixed from Darfuris that I spoke to, between anything you can try him on is a great thing versus, but how can you be trying him on that when he committed genocide against us? So I just don't think it's is it possible legally? Yes, but whether it is wise, I think depends very much on the views of the community, because the goal is often much less about can you get someone to trial, can you get hold of them, and much more about what is the truth and acknowledgement that comes out of that.
Hi, Babette Kenya from the Simon Scott Center for the Prevention of Genocide. I was really curious, in line with our conversation on holding corporate enablers accountable, what's our toolkit for holding state enablers accountable? And specifically, I'm thinking about like the UAE and Sudan. Is there precedent for going after other states? Is this something that could be done with universal jurisdiction? Just really curious on your thoughts on that. Thank you.
So you cannot bring a state in front of a domestic court, right? And there's no such thing under the law as a state crime. But what you can do, and what we've seen a really interesting development over the past couple of years, is if there is a relevant treaty in play, or if they've signed onto the jurisdiction of the court across the board, one state can bring a case against another at the International Court of Justice. And that possibility, this is one of these interesting things where that possibility was always there. And then it was like, nobody thought it was possible, and so no one tried it. And then we saw the floodgates kind of start to open. And Gambia brought this case against Myanmar under the Genocide Convention, and then everybody else sort of looked around and thought, well, hey, couldn't we do this in other forums? And now we've got South Africa and Israel, and we're going to, obviously, an interesting case in Russia, Ukraine. So that's the primary forum in a court setting for state actors. But really, most of the accountability for states as entities is happening not in a courtroom, it is happening through political, diplomatic, economic sanctions and other measures.
Can't go after the leaders of
Yeah.
the state or state policy.
So yes, so the individual leaders you can, they're just, well, we could get, there are some immunity provisions, but the short answer is that's a lot easier.
I'm just going to jump in with 2 quick points. One, Sudan did try to file a case against the UAE at the but somebody forgot to check, and the UAE had already carved out a clause that made them made an exemption for the Genocide Convention, which the United States has done too, which is why the United States was forbidden from joining as a third party for the Ukraine-Russia case. Second, I'm going to jump in with my own question. How about in regional human rights courts? How about, I mean, the Inter-American Human Rights Court has been really at the cutting edge of all kinds of accountability mechanisms for states for years. And we haven't heard much about the regional human rights courts now, because I think that criminal law has been taking up all of our bandwidth. So how about a quick, 90 seconds each, answer the question, what can be done to raise the power and visibility of regional human rights courts as atrocity prevention legal responses?
Yes, I think that regional courts are a very important actor too in legal teams and organizations and communities and victims can reach out to those courts too, not just to the ICC, but also to those regional courts. In the case of the Inter-American Court of Human Rights, actually it has been very active in sanctioning Latin American governments for their role in human rights violations. And some governments have acknowledged the truth, asked for forgiveness in several cases. So actually, I think that it's a very important arena for those working in prevention and prosecuting mass atrocities too.
No, I mean, Inter-American Court is being extraordinary, European Court it's going. The issue with the regional courts is coverage, right? We don't have a strong mechanism in Africa, we've got nothing in Asia, and so we're leaving vast chunks of the world out if we're relying on that. But that doesn't mean we shouldn't be using the ones that we have.
Great, we've only got a few minutes left, so I'm going to ask people I'm going to combine 3 questions. If we get to them, we get to them. We don't even talk over lunch. So first is Tabassum.
Well, hi, I'm Tabassum and I'm doing my master's in GMAT. So I'm following the Doe versus Meta case for a while now. So my question is now that we can see a shift in from bystander to become perpetrators in terms of using these platforms. So my question is what does this change means for new ideas about this platform accountability in international law? So yeah, and I'm really curious to know about the realm of the definition that white collar war criminals. So yeah, that's something literally.
Didn't you literally write a paper called Platform Enabled Crimes? Yes, you did. Okay, I thought I remembered that.
Very quickly, my name is Jennifer Glottemans. I'm from the former Office of Global Criminal Justice, and I just wanted to push back or challenge a little bit what may be a perception that there's a binary of punitive justice versus restorative justice. In my work in GCJ, I think it's a both and. And just as an example, when the Khmer Rouge Tribunal was prosecuting members of the Khmer Rouge, that was one of the biggest acts of truth-telling that traumatized country experienced in Cambodia, but also the convictions led to reparations that formed a restorative justice. So I just wondered if you wanted to suss out a little bit from that kind of a pushback, and thank you very much.
And Virginia, you have the last question.
Thank you guys for sharing your knowledge with us. My name is Virginia Hess. I'm a master's student with GMAT, and my question is, how do you start with localized, hybridized type of restorative justice, punitive justice in post-conflict societies that are still really raw, like Syria? How do you start?
All right, this should be very straightforward. Let's please each of you answer all 3 questions. 45 seconds each.
No, I agree with the idea of having an integrated framework, not just a binary distinction between the two approaches, but having an integrated one is very important. And to start a process would be a matter of big teams, wanting to do something that would repair somehow what happened. So of course we are talking about human rights violations, mass atrocities. So there's something happened, and maybe there's a community or a big or an individual or an organization that wants to pursue a type of process that would restore somehow the life of those who were victims of that event. And then, which goes back to your question of the reparations, needs to be thought beyond a traditional reparation that could be more administrative or maybe financial, but has to do with the way of life of that individual or community. So it needs to be thought as something integral, comprehensive, and beyond just a one-time act or grant or money or whatever is happening. The reparation has to be thought more comprehensive.
So I apologize if we gave the impression that it's a binary. It's clearly not. I think we talk about it at extremes to show the contrast, but it's everything and all of it together. And I should say, in fairness to the ICC, it made what was at the time a radical effort to the fact that it has a victims representative in the court, that it has a trust fund for reparations. So yes, on starting a process, just kind of foot stomping on it is always driven by survivors. Everybody else will move on because it's really, really hard to do this. And so then it's about figuring out how to support and stand in solidarity. But it is by definition hard because of what has happened. Platform-enabled crimes, we should talk over lunch.
I echo that. I will just add on Syria, right? On this, it will always be driven by survivors, and it will always be driven by civil society already operating there and having operated there over the last few decades, who know their community and know what they want to build. And that, I think, is the big debate right now of what will it look like in Syria, but it's already happening. It's already there.
Please join me in thanking our panelists for